Hello and welcome back to the video updates. It's Sade again. Today's video is going to cover the question that we get from heirs that are trying to assume a mortgage that was taken out by their ancestor or deceased relative. So typically the type of mortgage that was taken out would have been a reverse mortgage. Sometimes it's a home equity loan or a home equity line of credit or just a regular mortgage. And then when the person passes away and the heirs sometimes would hire an estate planning lawyer or a probate lawyer to sort out the inheritance. The probate lawyers will file whatever is needed to be able to get the will admitted to probate if there is a will, and they will then go through all the different steps to get to the end of the case. The will would name an executor or a representative, and so the court would issue some documents called letters testamentary, and those letters would name the powers of the executor in there. There will also be a document called an order to appoint an executor or to appoint an independent administrator or to appoint a representative. So there are different terminologies. The roles are slightly different, but they all serve a similar function, which is to represent the estate, sort out the assets of the estate, sort out the debts of the estate, and then also sort out the distribution to the beneficiaries under the will. So those are the different forms of documents that you would see if there is a will. Sometimes there is a will, but there is not any asset other than the real estate. So the probate lawyers can actually do something in some states called a muniment of title. And a muniment of title essentially just means as proof of title in the beneficiaries. So when the will, for instance, has only real estate in it, then the beneficiaries can go through a slightly less formal probate process called muniment of title. They can admit that will as a muniment of title, which means that admitting the will itself shows that the beneficiaries are now the owners of the property. They have title in the property. But what happens then when you talk to the lender that's holding the mortgage note? So the lender could be, as I said before, a reverse mortgage lender or just a regular mortgage lender, and you as the beneficiary, you'd like to assume that mortgage rather than selling the house or rather than getting a whole new loan with a different lender and paying off the balance of the existing mortgage. So what are your options at that point, and why is it that people come up against obstacles when they start talking to the lender? You've given them the debt certificate, you've given them the probate documents that you have, or at least some of the probate documents that you have that you think are necessary, and yet they're saying that they need more. So what is the more that they're talking about? Well, in my experience as a real estate lawyer, because the different areas of laws are distinct, they're different, and the probate attorney is doing an excellent job going through the probate process and getting the will admitted, proving everything up, proving up the heirship, and proving up the beneficiaries, right? So there are different things that could have happened in the probate court. The whole purpose of the probate is to show who the heirs are, but also show specifically who inherited under the will. If there is no will, it's going to be a simpler process. That's just a determination of heirship, and then all of the heirs will then inherit, because by default under state laws the legal heirs will inherit. And there are different parts of the estate's code, the statute, that tells you who can inherit and in what order. So that's what the lawyers would follow if there was no will. But in either case, whether there's a will or there's no will, there's always going to be a determination of heirship, and that then shows us what are the shares that the heirs would get. If the will specifies one particular heir to inherit, then that one heir would inherit. If the will specifies nothing and just says that all of my estate goes to all of my legal heirs, then they all would get it. Either way, we need to put title in somebody's name. So that's the reason why you would come up against issues with the lenders, because they don't want to read through the will. They don't want to comb through all of the probate documents to determine who is getting what. And because the probate lawyers are not real estate lawyers typically, they skip the last step. And that's because the order in the court usually already says who gets what. So the probate lawyers think that that's sufficient, and it is supposed to be sufficient in all honesty. But the lenders want something more definitive. The title companies also want something more definitive. So they want their work to be made easier. They want the chain of title to look more clear without having to jump around to a different court, which is the probate court, to find out, who inherited what. So what is that next step that I'm talking about? The very last step after the probate has been sorted out, after the heirship has been sorted out. The last step is going to be a deed that transfers the title into the heirs' names or the beneficiaries' names. So the last step would be a distribution deed if it's under a will, because the will tells us who gets what. And if the heirship is done in court and it's an informal sort of probate process, you could still use a distribution deed as long as a probate case was opened. And of course, some lawyers would use a warranty deed, and that's fine as well. But the distribution deed allows the lawyer that's preparing the document to put in more details as far as the probate case itself. And what we do at our law firm is we would attach an order from the probate court, a certified copy that shows under what authority we're putting together the distribution deed. So that's what I wanted to cover in this video today. Hopefully that's clear. So if you're having pushback from lenders when you're trying to assume the note or the loan from your deceased relative or ancestor, and they're saying that they're missing something, that's typically what they're missing. So you have a lawyer, you have to get a real estate lawyer to put that together for you. I think most states have that provision that allows somebody to put together a distribution deed, and the distribution deed will then show that the property went from the estate of the deceased previous owner to the heirs or the beneficiaries under the will. So all of that will be in one place, and it will be very easy for the title companies to pull it up and double check with the probate court, and they can find everything in one place. It's also easier for the lender to keep track of. So you would need a packet, an assumption packet from the lender as well, just FYI. So they will give you all of that, and they will still probably have to qualify you for the loan. So whatever the balance of the loan is would be how much you'll be borrowing. And so even though you're jumping in to assume the note, they want to make sure that you have the credit profile independently and you have the income coming in to be able to cover the note. I wanted to make sure I did this because the question comes up sometimes, and I figured it's better to do it in a separate video and keep it clear rather than doing it in the videos regarding assumptions. So if you have any specific questions that you'd like us to cover, remember to put a comment below, or you can also email us and we'll try to cover it on this channel. If you like what you're seeing so far, remember to subscribe so you can continue to get notifications. Thanks as always, and stay safe out there, and I'll talk to you next time.